Welcome to Tompkins Talks. It's time for another summary of a recent case in a short, snappy way that's easy to digest, whether you're at home, in the office, or on the move. Today I'm going to talk about the case of Poundland Ltd and Toplain Ltd. So let's get started with the backstory. Where business tenants have the statutory right to a new tenancy of premises pursuant to the relevant provisions of the Landlord and Tenant Act 1954, and the landlord doesn't oppose the renewal on one of the grounds within the Act, if the parties can't agree the terms for the new lease, they're determined by the court. In this case, Poundland wished to renew its lease of premises in Twickenham, and Toplain was its landlord. Whilst the parties were able to agree the majority of the terms for the new lease, including the annual rent of £130,000, there were a number of provisions which needed to be determined by the court. I'm going to focus on three of these. First, whether the rent should be paid in arrears. Second, whether a reduction to the rent should be applied in the event of a lockdown or similar circumstances. And third, whether the lease should include a term stating that the landlord should be responsible for works required to the premises to comply with minimum energy efficiency standards, or MEES. A key part of the backstory of which you should be aware is that the leading case when considering these types of matters remains the 1983 decision in OME and City of London Real Property Co Ltd, which in short determined that the court should have regard to the terms of the current tenancy, and the onus is on the party seeking to change from the current tenancy to justify that change is fair and reasonable in the circumstances. So bearing all that in mind, what was the outcome? The matter was heard in the Brentford County Court by District Judge Jenkins on the 7th of April 2021. The District Judge found as follows on the three issues I mentioned before. So first, on the question of whether rent should be paid in arrears, despite the tenant's argument that this was their standard position across the portfolio and paying rent in advance was an unfair balance between the landlord and the tenant, the judge did not accept this was sufficient to justify a change to the current in-advance payment structure. 2. On the COVID rent reduction clause, the tenant referred to the recent W.H. Smith case, which I'm sure you've already all watched my Tompkins Talks on, and said it was in line with similar clauses agreed between many landlords and tenants over the past 12 months. The landlord countered this by saying that the clause would fundamentally change the relationship between the parties, and that if there were further lockdowns, the tenant would be able to take advantage of relief offered by the government. The judge sided with the landlord on this and referred to OME, finding that it would not be fair and reasonable to include this provision. It was not the purpose of the Act to insulate the tenants or redesign previously negotiated risks, the judge said. The judge also distinguished the W.H. Smith decision on the basis that the parties in that case had agreed to have a COVID clause, but simply could not agree what the trigger to that clause would be. So 2-0 to the landlord thus far. Could the tenant pull a goal back on the request that the lease included a clause requiring the landlord to be responsible for works to comply with MEES? Well, the answer was yes, it could. The judge held it was reasonable to give clarity to the parties that the landlord should be responsible for such works. So what does this mean? The important first point to note is that this is a county court decision, so it's not binding. However, it does provide useful guidance on these points, and I can see landlords referring to it when seeking to resist COVID clauses. The point on MEES has perhaps flown slightly under the radar in the reviews of the case I've seen, but I think it's important to note, particularly as so-called green clauses are becoming more and more contentious on renewals, so it's certainly something tenants might want to refer to in that regard. If you found this useful, please comment, like, or share the video. I'm going to take a break from these for August, but I'll see you all in September for another Tompkins Talks.